Hello, everyone. My name is Devlin Hartline, and I'm legal fellow at the Hudson Institute's Forum for Intellectual Property in Washington, D.C. We have a wonderful panel for you today on some issues that have been making headlines recently as new copyright challenges for the publishing industry. The commonality of these issues is that they continue the debate over how copyright law should work in the digital world. One of these issues, digital for sale, has been discussed for years. The notion is that digital copies should work just like physical ones, and people should be able to sell or give away the digital copies that they own. The problem with this theory is twofold. Most content nowadays is licensed, not sold, so people don't even own their copies. And even if they did own them, they can't be distributed online because that necessarily means they're making a new copy. Nevertheless, proponents of digital for sale have persisted for years, either trying to change the law or even worse, pretending that the law doesn't even need to be changed, but they haven't made much headway either way. These debates about digital copies continue to this day, and those hoping to change copyright law have found new theories to support their quest to weaken the rights of publishers and authors. The controlled digital lending theory picks up where digital first sale leaves off. And it posits that libraries can copy the books on their shelves, digitize them, and then distribute those digital copies all without a license. States have also gotten in on the action, and there are laws on the books and in the works that purport to mandate the licensing of digital literary works, such as ebooks and audiobooks, to public libraries on terms that the state finds reasonable. And finally, news publishers are facing competition from online news aggregators that take views away from the original source and diminish profitability. To discuss all of these important issues and maybe some other ones, we have a great group of experts here today. We have Terry Hart, who is general counsel at the Association of American Publishers, Danielle Coffey, who is Executive Vice President and General Counsel at the News Media Alliance, and Umair Kazi, who is Director of Advocacy and Policy at the Authors Guild. I'm thrilled to have this dream team gathered to discuss these topics and how they present profound implications for the publishing industry. That's publishers as well as authors. We'll start with opening remarks from each panelist, and then we'll have a moderated Q&A to fill out the rest of the time. And with that, I'll turn it over to Terry.
All right, thank you, Devlin, and appreciate the invite and the opportunity to talk here. So the Association of American Publishers, or AAP, is the national trade association which represents publishers in trade, education, and scientific and scholarly publishing. In total, the US publishing industry generates between $25 and $26 billion a year, but the value of books goes far beyond their economic contributions. They make critical contributions to our intellectual, cultural, and political lives. Now, for books, the predominant business model in the physical world is the sale of physical items. But in the digital space, as Devlin mentioned, licensing is critical to business models, and that's really for three primary reasons. First, digital files lack the physical friction of books that naturally limits who can access that work. Second, there's no concept of a used file because files don't degrade, and every copy is a perfect replica of the original. So every downstream use can compete directly with the primary market. Finally, there's a greater risk of infringement because perfect copies can be made of digital files, and they can be made instantaneously and shared worldwide. Now, as Devlin mentioned, some copyright critics have argued in favor of a digital first sale doctrine. That is, the law should ignore these fundamental distinctions between physical items and digital transmissions and try to shoehorn that physical paradigm into the digital space. First sale is a long-standing copyright doctrine. It says that when a copyright owner distributes a particular copy of a work, the right to control further distributions of that particular copy is exhausted. So used bookstores and libraries can resell and lend copies of books they purchase. The first sale doesn't exhaust the other exclusive rights protected by copyright. So if you buy a copy of Frank Herbert's Dune, you can't, for example, adapt it into a film without Frank Herbert's permission. That also means that when you have a digital copy of a copyrighted work, you can't sell or lend via digital transmission. Because when you transmit a digital file online, you're not physically transporting the file from one place to another, but you're creating a new copy of that file. On a side note, publishers have nevertheless worked with libraries to provide licensing models that allow libraries to provide access to digital materials to their patrons. And in fact, all of the biggest publishers today make their entire ebook catalogs available for digital library lending. Congress, federal agencies, and courts have repeatedly rejected digital first sale proposals over the past 30 years. But undeterred by these setbacks, digital first sale advocates have recently tried a couple new approaches. First, a group of academics have concocted this legal theory that they call controlled digital lending, or CDL. CDL refers to the practice of an entity creating an unauthorized digital copy of the physical work and then making that copy available online without the permission of the copyright owner. The controlled part of the name refers to the set of requirements that are contrived by the proponents that they argue replicate with digital lending the legal and economically significant aspects of physical lending, and which they believe is sufficient to make the process lawful. So under the guise of CDL, the San Francisco-based Internet Archive has been systematically digitizing and providing public access to complete copies of copyrighted books through its open library. And as of 2020, the open library provided unauthorized access to 1.3 million titles. In June of 2020, a group of publishers sued Internet Archive for copyright infringement, asserting that Internet Archive directly harms the plaintiffs' print and ebook markets in all market segments by providing competing substitutes for numerous original works currently available in their catalogs. And that lawsuit is ongoing. Second, advocates have turned to the states to pass laws that would both compel publishers to license all their ebooks to libraries and then create government regulation of the terms and prices under which publishers can license ebooks to libraries. These bills were motivated in part by mischaracterizing the operation of first sale in the digital environment as a, quote, loophole that publishers exploit at the expense of libraries. These bills, first, they're unquestionably preempted by federal copyright law. Of the two bills that have been successfully passed to date, one was vetoed and the other enjoined by a federal court on those grounds. But setting aside the legal issues, they lack any justification. The complaints that publishers' licensing practices are unfair and discriminatory are unfounded, and they recast the ordinary exercise of exclusive rights as inherently anti-competitive. And notwithstanding the legal issues, the harm of such bills is that they interfere with business decisions that are the responsibility of publishers and their authors to determine, and that will have negative consequences on publishing in both the short and long terms.
Thanks, Terry. Yeah, it's super interesting, and I have a follow-up question. So the lawsuit against Internet Archive, like I feel like I was hearing a lot about it because they had, what did they call it? Like their emergency library, and this was at the beginning of the pandemic, and they're like, okay, all bets are off. We're gonna put out millions of books without a license online because it's justified by the pandemic, and they got sued. But I haven't heard anything recently, so I'm assuming you said it's still ongoing. So what is happening in that case? Are they just doing discovery, and maybe there's some kind of dispositive motions coming soon?
Yeah, with any litigation, there's usually these bursts of public activity and then a lot going beyond the scenes. So yeah, The case is currently in discovery, and it's continuing discovery through the next couple of months. But currently, if everything stays on schedule, we should begin to see briefing for summary judgment motions starting in midsummer, around July.
All right. Well, I'm excited about both both of those topics, and I can't wait to see what happens in that case. I think it's going to be very interesting. So thanks for that summary. Danielle, tell us what's happening in with news and press publishers.
Absolutely, and thank you very much for having me, Devlin. I'm pleased to participate with with this group. We work with Umar and Terry often. I represent the news publishers, the News Media Alliance's newspapers across our country and internationally. And like Terry said, like books, news content, quality journalism is going digital because of the advent of the internet. We reach millions upon millions of readers. Whereas we no limitations like we used to have when it was print circulation. So when it comes to quality information about what's happening in communities and around the world, especially during the pandemic, we saw everything became very local, and quality, reliable content becomes all the more important, especially when you're talking about health or schools or what have you. However, so while we have a 10 times exponential growth in our readership over the past 10 years because of the internet, unfortunately, in the case of news publishers, we have two dominant distributors. We have two monopolies that act as intermediaries for our content to our readers. They sit in between us and our readers, and that's Google and Facebook, unfortunately. And I say unfortunately because while we have all these readers, our newsrooms are still closing. So you wonder what the disconnect is there. If you're making something that people enjoy and consume in great volumes, where's the monetization of that content? Unfortunately, the revenue is going to these distributors, just like it has in cable and telco in the past, when you have a gatekeeper who reaps the reward and benefits from the content that they're distributing. So like those cases, the government needs to step in and they need to correct that marketplace imbalance so that the revenue goes back to those who are creating the quality content, in our case, news, local and national news coverage. In our case, we're not compensated currently because 65% of users stay within the walled garden. So we don't actually get compensated for any of that content that their readers of the platform are consuming. And then when readers do click through, there's also a broken advertising ecosystem where there's dominance on the demand side and supply side, which I won't go into, but just to say that we only get 30 cents of every advertising dollar. So that explains the broken marketplace. That explains why we don't have the revenue to invest back in reporters and newsrooms, which is why you see newsrooms closing and so few reporters covering town hall meetings. There are claims that there's a thin copyright, and that's been over the last decades just because of a string of court decisions and so forth. However, I would argue otherwise, and we even have recommendations with the Copyright Office that would clarify what is actually a strong copyright and our exclusive right to distribute our copyrighted content. In the case of the dominant distributors, however, what we learned in Europe is that your rights are only so good as your ability to assert them. So with a dominant monopoly, they'll say, take it or leave it. And so you have to waive your copyright, and it becomes what's called a Hobson's choice. It's kind of like asking someone if they want air. It's not really a choice. Of course, you're going to want to be surfaced and be found in this only way that readers are receiving the content, but you have to do so at no cost. Hence the broken marketplace. There's legislation pending in Congress. It's called the Journalism Competition Preservation Act, the JCPA. And it really addresses the competition issue and not the specific uses of the content. So it's again, like, different distributors of the past where it's just access and not necessarily how they use it that you're requesting to be paid for and compensated. I won't go into the details of the legislation. I'm happy to later, but we do believe that it is a legislative fix to an urgent problem that really only government can solve, because no one news publisher can withhold content on their own. So it lets you collectively come together to be able to demand compensation for your content. And that is moving through Congress currently. It was just revised to be strengthened because Australia, Europe, now Canada have legislation that has allowed those news publishers in those countries to be paid. And so the United States lawmakers are looking at this and saying, well, we're incentivized to protect our news publishers. They value quality journalism like any other country. So our lawmakers have taken notice and they're pushing forward with the JCPA. I won't go in. There's a lot of details there that I just, gave a cursory overview about, but hopefully that gives you a snapshot of what news publishers are experiencing with a great product, but not a lot of return.
So I haven't really followed the news and press publisher stuff as closely as I have like the other issues. But everything that you were saying right now, I've heard it all before, but in the context of the music industry, right? So there's a growth of readership. More and more people are consuming these works. And so you would think that's great and revenues are up. But they're not, right? They're actually going down. And so there's something happening. There's something that's distorting the marketplace. And so copyright isn't working as it should. And so you were saying it's these intermediaries. And so, and these are the names that I've heard in other contexts too. But, the Googles and the Facebooks and all that is they're having a profound effect on and depressing the market. And so this is a huge problem. And I'm glad to hear that there's maybe a legislative fix. That's wonderful news. And so I'm so glad you're here. And I can't wait to hear more about how these issues affect news publishers. But first, before we get to the Q&A, let's get to Umar. I want to hear, how, from author's perspective, how do you guys view all these things? Because you're an integral part of this publishing ecosystem.
Absolutely, and thanks, Devlin. We have been involved in we supported the JCPA. It's something, the problem of gatekeeping and the decimation of newsroom jobs and revenues is very much something that affects our members. A lot of our members, I forget exactly off the top of my head, but I think it's in the couple of thousands, are journalists, working journalists, and also other authors rely on supplementary income through publishing with newspapers and magazines. So the press publishing issues are also very much on our radar, and we responded to the Copyright Office's study and have worked with Danielle's wonderful team to support the JCPA. I think of the kind of three major areas that we have discussed so far in this talk: digital first sale, press publishers, and CDL. CDL has been the one that the Authors Guild has been most sort of consistently been involved in for a long time, having dealt with Internet Archive's various projects and digitizing works of authorship without the permission or compensation from the authors. So I'll focus my remarks on what we've been doing on CDL, because I think the other panelists have wonderfully covered the two other areas. Virtually every author group, including the National Writers Union, Textbook Author Association, American Society of Journalists and Authors, and many photographer and publisher associations opposed the CDL. And we've really pushed back on this notion that controlled digital lending, the copyright infringement that's inherent in controlled digital lending is a victimless crime. As Terry mentioned earlier in its talk, CDL. I'll just briefly recap what we mean by CDL when we talk about it. Is taking is an unauthorized scanning of a text that might be in a library's collections. It doesn't fall under the 108 exceptions, and then making that digital copy available through internet lending. It implicates other areas of copyright that Terry has also talked about. So I won't really go into that, but that's sort of the gist of it. And Internet Archive is the main sort of I guess it might be the only library outlet right now that's really applying CDL and the National Emergency Library and Open Library as well. The application of CDL initially, as far as I know, initially it was sort of pitched as a solution to another kind of an issue in copyright and publishing, but not exactly in the same way as it's framed in the CDL discussion. But the problem of orphan works and mass digitization. The application, however, of CDL has sprawled way beyond that. So in the Internet Archive, what we often see are books that are still protected by copyright. Their authors are still alive and identifiable. And the books, nevertheless, because there is, in some cases, there might even be an ebook version, but in many cases, there hasn't been an ebook or an electronic digital version of the text that was produced, and then the archive scans the physical copy and makes the scan available as a digital file. The protections that are applied to the digital scans are, they're not super robust. DRM, as we know, is not a by any means a firewall. It's pretty easy to crack DRM. There's tons of tutorials online on Reddit and other places that you can that teach people how to break DRM. So this presents a problem for rather like a possible source for piracy of books that just don't exist in an electronic form in the first instance. So that's one of the problems. The main kind of objection that, or the notion that we have really pushed back on, and I think this is a notion that often surprises people, but having worked at the Guild for 7 years, it is, and having worked with authors from authors in their now who are in their 70s and had books out many decades ago and are sort of republishing them or have their rights reverted and are bringing them out again. It's no surprise to me. But the notion that out of commerce books have no value for the authors and that are, in quote from the white paper, unavailable in the digital marketplace, or no one has any plans for revitalization in modern formats. What this misses is that just because a book has gone out of print doesn't mean that the authors are not interested in revitalization. And in fact, like the fact, because author incomes overall are sort of going down from sources, it is very important for us to keep this revenue stream, open for authors. The proponents of CDL also wrongly argue that there is no market for older books, and we help. I've helped hundreds of AG members who sign new contracts every year or self-publish their old books, whereas a publisher might find that it's not worth the publisher's while to keep a book in print anymore and keep trying to sell it because that's a very different model. An author might be thrilled with a new deal, even if it's not a whole lot of money. But if you're in your 70s and your book is still around, that's there's I think we talk about like the kind of the mechanics and the economics of publishing, but that picture doesn't really include is the very personal and emotional connection that an author has to this work that they've made, and it's the abstract sort of variable, no author wants their book to languish out of print. And, we certainly as an organization believe in widespread access. And we've worked over the years to propose licensing solutions to bring out of commerce books and orphan works into the digital realm so they can remain viable. It's the CDL model just cuts out the author, and it's clearly unpopular because we launched an open letter against the National Emergency Library when it first came to the fore, and within a very short time, we had over 6,000 supporters for the open letter. Hundreds of complaints every year about unauthorized digitization of books when authors find them on internet archive outlets. We then direct them, they get the books taken down. But it is it's to say that authors do not like unauthorized use of their works. They're probably more than happy to grant permission for library use, and in fact, if there was a kind of collective licensing program for this, they would, many authors, I imagine, would voluntarily sort of put their books in. But it is sort of crossing the line when you just scan someone's book and start lending it out. I'll just quickly mention on what we see at CDLs, what we see as CDLs threat to author incomes, and it comes from two directions. One, the unauthorized scanning and e-lending of books that were previously published only in physical forms usurps the market for creating new ebook versions. And two, instead of purchasing library ebook licenses, which tend to be more expensive than consumer editions for good reason, libraries would simply digitize their print book collections, and that would completely cut off the authors and publishers of that licensing income. And it's an important part. It's an important source of revenue for authors. The one other concern that we have is that a widespread, acceptance of CDL as a copyright exception would it really just enables anyone to set up a website and call it a library and digitize books and lend them out, because this library model is not yet in place in the copyright. It's not like the 108 exceptions. We've talked about ReDigi, and ReDigi, the court actually held that market harm was likely because lower priced resales, sold to the same customers who would otherwise have to purchase new licenses, usurp the market. So all of this to say, it continues to be something that we monitor and push back on. The solution that we have proposed over and over again in the Google Book settlement is a collective licensing scheme. So far, that has not come to pass, but hopefully, that solution will present itself soon.
Yeah, great. So I'm hearing from all of you that copyright licensing is good. Unless you're big tech, then that's friction, and they don't like friction. And so to me, that friction is like a free market that's working correctly, right? And so the thing about Internet Archive, I went on their website yesterday just to take a look around, and I'm always just rolling my eyes. I can't believe that they're still doing this, and hopefully not for much longer. But it seems to me. So Umar, you mentioned Section 108. So this creates certain exceptions for libraries and archives, and so you would think that Internet Archive would be interested in trying to change the law in Section 108, but they're not. In fact, they have a blog post on their website bragging about how they refuse to even meet with the register to talk about, Section 108. They don't want to change the law, right? They see that, digital first sale is just a theory, and they're like, okay, we're just going to go with digital first sale. But it's not even really digital for sale. What they're really arguing is that it's fair use, right? That they can copy these books and distribute them. Well, they can't get around the fact that, they're making copies. There's several copies, right? They're making copies when they scan the book. They're making copies when they distribute the book. So they can't really get around that. So they say, oh, well, all that copying and distribution, it's all fair use. And so as you know quite well, there was these authors guild cases in the Second Circuit, and this was about they were going to libraries and digitizing millions of books, and so the Second Circuit actually said that digitization was fair use, and it was okay if they created like Google Books, which gives out snippets of text. Like that's fair use. Okay. So they won that victory. And now it seems like they're just trying to take the next step and say, okay, well, if we can put out snippets, we can put out the whole book. But if you read those two cases in the Second Circuit, it's very clear that they were limited to snippets. And if it had been entire books, it would not be considered fair use. But that hasn't stopped them. And so the topic I want to throw out, and this is for the group, is I read a lot of academic literature, and I'm always amazed that these positions that I think are like very extreme positions all find these academics to back them up, right? So you have academics who argue that controlled digital lending is perfectly fine. In fact, I did a debate with one of these academics last year, and I strongly disagreed, but I'm amazed. And it's not just academics, it's many of them are also librarians. And so I'm just wondering, what do you make of the fact that academics say controlled digital lending is fine, state compulsory licensing is fine, we don't have to worry about news publishers? Why is academia seemingly against copyright owners, authors, publishers, making a living? Any theories out there?
I don't have any theories, but I do find it kind of strange as well. But at the end of the day, it's like none of these issues have been decided by a court, right? So this is theory land that kind of becomes practice until a court comes down and says no. But maybe Terry and Danielle have a better idea of the the mindset.
What I find it surprising as well, just because I find it so short-sighted to think, there is this philosophy, information wants to be free. And another thing that we also find challenging is that, especially with the advent of the internet, there's a consumer expectation that everything's free. However, the reason why I believe it to be short-sighted is because if there isn't a return on that investment in creating the quality content, whether it be books, news content, or music, that was a good analogy, Devlin, that you raised before, then you're not going to have that quality content in the long term. And we've already seen that happening with the frankly garbage on the internet that we see that isn't vetted, that is just totally false by any definition. And that's where we're going to be headed for our society if we don't reinvest, and if we don't have some controls, those constitutionally, that was the purpose of the, to incentivize the fruits of one, to be able to reap the fruits of one's labor. It's a good point as far as the systematic uses. We feel strongly that when it's an entire, it's a systematic use should be taken into account when doing any fair use analysis. We also believe that transformative use has been over broadly interpreted and has now swallowed the rules. So there are changing, even in the Second Circuit, I believe we've seen changes in some of the court's philosophies around transformative use, and also systematic uses that we believe have a market impact, so that you can undo an entire industry if you don't take into account the balancing of the scales that's necessary for some of these interests in information being free. What we like to say is information wants to be free, but reporters need to be paid.
And all great points. I would throw in just one additional observation, and that's there's been mention of how big tech really benefits from weakening the legal framework of copyright and getting access to high quality content without, needing permission or needing to pay for it. And they've spent a lot of money on supporting academics. So I don't think it's surprising to see, when you're putting dollars into supporting certain voices, that those voices are getting amplified.
Yeah, I'll just very quickly mention to Terry's point that Google Books was before my time at the Guild, but I've worked on it's a sort of the long shadow of Google Books. But there were Google engineers at the time who were saying, openly to the press that we're not digitizing these books for any, particular charitable purpose. We're doing it to train our, language processing algorithms and to like improve our search capacities and hence improve our advertising, advertising potential. So there you have it. I mean, it's from the horse's mouth in a way.
Yeah, so my last panel was on AI, and we talked about those issues.
Yeah.
But no, they're not doing it out of the kindness of their heart, right? Yeah, and so it's interesting. So Umar, you mentioned that these things haven't been litigated, but we actually do have the ReDigi case, right? And so in the ReDigi case, they claimed that so what were the facts? So they had these music song files, and so you could sell it to somebody else, and then the software would like delete the copy that was on your hard drive. Mm-hmm. And so even in that case, I remember there was an amicus brief, and it was signed by dozens of like IP professors, copyright professors at like leading universities, and they said with a straight face that with ReDigi, no copies are made. And I was just like, really? And so the Second Circuit completely shot that down. It was like, there's absolutely a copy being made when you distribute a work to somebody else. But it just like, it blew my mind that these people were willing to sign a brief saying that no copies are made when it is so clearly the fact that they are made. And the only case that they had to support their claim was some weird case where it was like an image on a tile, and they like used a chemical process to like remove the image from the tile and put it on another surface or something. And I was like, okay, well, in that case, there's no copy being made, sure. But what they ignored was like the entire body of case law of how copyright works on the internet. And they're just willing to say, oh, none of that stuff exists, because it seems to me like, this is results oriented, right? And these are people, they're making legal arguments, but it's really their policy arguments. And the policy is that frankly, they just want to see the rights of authors and publishers be weakened. They're not too worried about it, which it kind of blows my mind. And it's not just academics, it's librarians, which is really confusing to me. It's not all librarians, obviously, but there are a handful of outspoken librarians who are very skeptical of copyright, which to me doesn't make any sense given the symbiotic relationship, right? And so I want to throw this out there. I've seen people who are blaming all of these things on publishers, right? This is your problem. And so we live in a world where there's Netflix, and I don't know what Netflix costs, $15 a month. It's all you can eat, and everything should be like that too. It's that way in the music world, right? I have an Amazon Music subscription, and so I can listen to millions of songs, and so this is the world we live in. And so they look at publishing and they're like, why can't I get that kind of stuff? And obviously you can if you have a subscription to something like Audible or something like that. But it seems to me like there's a lot of victim blaming. And I'm just wondering if you see it the same way. And what do you make of that?
I could probably jump in here just because I don't know. I can't tell you how many times not a day, but I'm often asked, why don't you do Spotify for news? And it's a good question. And it's a good analogy to talk about the all you can eat, or offering it in the way we're, as news publishers, we're very adaptable. Actually, some might be surprised to hear that, but we've had to adapt. I mean, you have a history of hundreds of years of doing it one way, and then you transition. And they have transitioned. Our digital content is through the roof, and you have to work with your readers to deliver it in a way that that whets their appetite that they can consume it. The Spotify model would be, we have great case law that substantiates such a model, that would support such a model with regard to the AP Meltwater case, what have you, and all the follow-on precedent that would support such a model. However, again, in the situation where you have the dominant aggregator, 70% of our news goes through two companies. So it's not illusionary that there are two companies that distribute our content, and they do it for free. And so the aggregator offering a free product, it's very difficult to compete with free. So when you have Google News or even search, you call it an aggregator, that offers with these rich snippets that have headlines, and many argue, Jane Ginsburg in our filing argued that even headlines themselves alone, without the summary that they provide in search, are original, and they give you the experience so that you don't have to click through to the content itself. And that might be a Spotify model. It's not like music where you get the first 10 seconds of a song, you want to listen to the whole song. It's different. It's also, we don't have also a back catalog like music. Ours is very, the nature of news is breaking for the most part. So it's different than a Spotify model. However, the business model would have a difficult time seeing the light of day when you have an aggregation product that is free. There's legislation, I won't go into, but there's legislation that addresses self-preferencing. It actually just passed in Europe. It's called the DMA, that also included the JCPA like collective, the compensation aspects of it. But other parts of the DMA actually included self-preferencing, so that, if Google has this free product, which they have control over, and Google likes free. That's why first click free lasted for so long. Recall, first click free was the policy of Google. Readers like free. So news publisher, you have to offer your articles for free. It was back in the day when we couldn't do paywalls. I don't know if people remember that, but that finally ended just recently, which is, it's scary to think that just recently we were allowed to do paywalls in Google. And so if you had to allow quality and competitive products in addition to Google News in their verticals, and you had to showcase them as much as you did their own preferred product, because you only get Google News through Google, there's no other aggregation product, they only offer Google News, then maybe that might start to rebalance what could be made available, such as a Spotify model for news publications. But while they're being tried, and it's been very innovative, Smart Brief, which licenses our product, I can name 20 others behind them, is very difficult when you have free.
Yeah, thanks for that. And it's such a problem, and so it's just interesting to me that to me it feels like this, they have solutions in search of a problem, right? I have like more content available to me in music, books, movies, news. I subscribe to legal services. I can't even consume like 1/10 of the content that I subscribe to, and to me, this is an amazing world, and it's all thanks to copyright licensing. And I just absolutely love it. And I just can't believe like all these people out there don't understand that there's an ecosystem, right? And so I want people to get paid. And like with Amazon Music, I feel like it should cost more. Like I don't think some of these models are charging enough for content, and I'm happy to pay more, right? Maybe I'm in the minority there, but so I want to ask you guys, right? So the people promoting these things, controlled digital lending, state licensing, all that stuff, is they really don't talk about the harm that it creates for the publishing ecosystem. They just kind of brush it off. And even though a lot of these things are based on the notion of fair use, right? And so one of the fair use factors, probably the most important one, is the effect on the market for the original. Like, are you causing market harm with this use? And if you are, then it's probably not fair use. But more recently, we've had a lot of talk about transformativeness. And so that's taken on new importance. Is it a transformative use? And if it is, then it seems like that will dominate all of the factors. And we just got the news this morning that the Supreme Court is going to take a fair use case. It will be next term, according to Terry's tweet this morning. And I responded, for reasons we don't have to get into, but so I'm excited. It's a case about Andy Warhol and the musician Prince, and I was like, great. The facts are great, right? And I thought the appellate court decision was great, but now we're actually going to have the Supreme Court come in, and I'm a little bit worried because they talked about fair use in the Google v. Oracle case, but that seemed to be pretty limited. This case, there's a chance that they might say some really broad things about transformativeness, which they haven't said since the Campbell case, right? Which was, God, what was that, 25 years ago, right? So I'm a little worried about that. But anyway, so, it matters in the fair use analysis how these things, hurt authors and publishers. And so we're running out of time. And so I wanted to finish on hearing from each of you all, like, how do these things actually affect the bottom line? And if you could tell us just your experience there. Don't all jump in.
Yeah, I can start first. I mean, I think bottom line is that, copyright creates economic incentives in markets for works, and economic incentives matter. And the positions, that publishers are advocating against, whether it's CDL, whether it's state compulsory licenses, they weaken those incentives, and they do it in ways, I think, that are self-evident, but also in a lot of ways that are hard to quantify. So, just one example of what I mean. One of the roles of publishers play is in aggregating risk, right? So if you imagine any book that goes out there, every book has some risk to it. You really can't tell beforehand with any level of certainty, like, how successful it'll be in the marketplace. And that's true with any copyrighted work, really. But when you're a publisher, you're not just putting out one book, you're putting out multiple books at one time. So in a sense, you're diversifying your risk. You're creating a risk portfolio. And what that allows you to do as a publisher is it enables you to take chances on books that may not be certain commercial successes, but are important nonetheless. They're important to reach their audience. It's important that they're out there in the marketplace, despite not knowing, whether you'll earn your money back. And so, when you weaken the incentives that publishers rely on and the legal framework they rely on, you're narrowing the range of books that publishers can take chances on and books that'll be published. And you're left with really only those books that have some certain commercial potential behind them. And there's nothing wrong with those books. We all love those books. That's why they're commercially successful. But I think, our society would be much worse off if that's the only books you see on the shelves. And so bottom line, that's my biggest concern, is that there's these efforts weaken those economic incentives in ways that we can't really see and we won't really be able to see for years to come, going towards the long-term success of publishers and authors.
And that,
and I'm sure. Go ahead, Mark.
No, I was just going to say that is also our biggest concern. I mean, Terry just I guess spoke both for having a diversity of voices in publishing, having the publishers having the risk sort of latitude to be able to take chances on debut authors. There are so many authors I met at this conference in AWP. I mean, they're literary authors, and they don't really, like, their books don't sell enough to pay back their advances, but yet they're able to sort of like, have a career. And we would like more of those authors in Midlist, because ultimately it's there's abstract value to having that sort of cultural, the cultural current. Otherwise we would be stuck with the same, like 4 genres and, the bestsellers and celebrity biographies, which, I'm sure, like, I don't really, I'm not personally a reader of celebrity biographies, but I'm sure they're also enriching. But maybe not. We also need literary fiction.
Okay. Especially after the Oscars last night.
Oh, the next Will Smith biography is gonna be
yeah, I'll read it. I didn't want to go first just because I think it's so obvious what the answer is for the news publishers. There's a commercial impact, obviously, and financial, and that's easy to say when you go into a member of Congress and you want to show standing because jobs are at risk, economics are at risk in your state, Mr. Senator, Mr. Congressman. So I think that those numbers have always been there. It gives us the ability to argue for what it is that we need from their help on. And I think that those financials speak for themselves. However, with, like Terry said, the societal impact on not just lowering the value the quality of the journalism that's produced, whether it be, the information that's provided to a local community or, the inability, and you'd never know the negative loss. You can't prove that negative of what isn't uncovered because you don't have a reporter on a beat that follows up on a lead that leads to Jeffrey Epstein or, that covers, the hurricane and how the city reacted to it, whether the mayor, did his job or what have you. You can't quantify those losses to society and the value that goes down. I was just asked, and I'll just say as a little anecdote, I was just asked by Senator McConnell's office, because I don't know if you know this, but 2 weeks ago, their last daily newspaper closed. So they have no more daily newspapers in the state of Kentucky. And they were concerned. And their question was, they're supportive of our legislation. So they said, is it too late? Is it too late for the legislation? Because everybody knows that when a newsroom shuts down, it's difficult to reopen or fill that void with something else. I mean, reporters are reporters. We don't have citizen reporters like you have on Facebook. That photo of something will never be the same. And what I said, I was very honest, and I will be with you as well. I can't say that those papers will go back to 7 days a week. I don't know that that's going to happen. If they've gone down to 3 or 4 days a week, and we receive the compensation that we're deserved, that we're owed, that's commensurate with the value, the incremental value add you also asked previously. So I'll answer that question real quick. The value add is the incremental increase to the platforms that they receive because of directly attributable to our content. If we actually receive that compensation and reinvested it, would the paper come back to 7 days a week? I don't think so. It would probably be a 3 or 4 day a week. They would stay at that. A printer closes. And you have fewer printers to print the same product. The paper would become thicker for the days because you'd have more reporters. You'd have more reporters showing up for town halls and city hall meetings and covering the critical aspects of the community. It came down from 100 to 12 in the case of Senator Durbin's remarks, and now it could go back up to 100. It would also, we would utilize the internet like we have and be able to just push out more quality content in the digital space. Again, that's something that we're striving for. There's just no return, and that's proven by BuzzFeed, what's happening with them. It's not our old business model. I think that there's proof that even new innovative digital native entrants can't even make it. So that proves that the marketplace, that there's something broken. And that's what needs to be fixed so that you can continue to provide that societal value.
Yeah, no, I think it's so important. I don't know if you guys saw Inventing Anna. I think it was on Netflix, and it's Anna. Well, Klumsky, her name happens to be Anna. Yeah, so she's a reporter and she's digging into this story, and she spends like so much time and like traveling and all this stuff. And I was like, how great is it that she has all this support? They could actually do this in-depth story that just takes so much time and so much money to create, right? And what a shame, if we're losing that. And I think it's such an important thing. Like, books, news, all of this stuff. This isn't buggy whips like being replaced by automobiles, right?
Right.
This is stuff that everybody likes and everybody consumes. And in fact, they consume it now more than ever. Yeah. And yet the ecosystem that guarantees people getting paid is being eroded by the internet. The great promise of the internet and disintermediation and all that stuff. It seems to me like it's not really working out the way that it should. And so anyway, I want to thank you guys, all of you, for being here today and talking about what I think are really important issues. And hopefully some people have tuned in who aren't familiar with any of these issues, and now they have some idea about what's going on. And like I said earlier, this was a dream team for me, and I'm so glad that all three of you took time out to be here today. And I will be looking for you on the internet and following all of your stories. So thanks a lot to all three of you for being here, and thanks for everybody for tuning in today. Thanks, and have a great day.
Thank you, Devlin.
Thank you.
Thanks, Devlin.